Hello students, in this model we are going to discuss what is patentable in India, what cannot be patentable in India, what are the important patentable criteria. What is patentable? Whoever invents or discovers any new and useful process, machine, manufacture or composition of matter or any new and useful improvement thereof may obtain a patent, therefore, subject to certain conditions. What are the requirements for a patent? It should be novel, it should have inventive step or it must be non-obvious, it should be capable of industrial application, it should not attract the provisions of Section 3 and 4 of Indian Patent Act 1970. What is an invention? Indian Patent Act Section 21J define invention. Invention means a new product or process involving an inventive step and capable of industrial application. The section talks about three important criteria of an invention. The first one, it should be new. The second one, it should involve an inventive step. Third, it should be capable of industrial application. So we need to understand the term what is new, what is an inventive step, and what is capable of industrial application. So in this slide, we are going to discuss what is new. What is new product or process, or what is new invention. Under Section 21L, the Indian Patent Act 1970, new invention means any invention or technology which has not been anticipated by publication in any document or used in the country or elsewhere in the world before the date of filing of the application with complete specification. That is, the subject matter has not fallen in the public domain or form part of the state of art. Means the invention should not be published in any kind of document anywhere in the world. The invention should not be in public use anywhere in the world before the date of filing of the application. The important point is date of filing of the application, a date on which the patent application has been filed. So before this filing date, the invention should not be published anywhere in the world, should not be in public use anywhere in the world. This is the important criteria required for a new invention. So now we need to understand what is inventive step. Under Section 21JA Indian Patent Act, the inventive step is a feature of an invention that involves a technical advancement as compared to the existing knowledge, or the invention should have economic significance, or both, and that makes the invention not obvious to a person skilled in the art. It is called inventive step. So the third important criteria for a new invention is capable of industrial application. Under Section 21AC, the Indian Patent Act 1970, capable of industrial application means that the invention is capable of being made or used in an industry. Till now, we have discussed the patentable criteria, novelty, inventive step, and industrial application. Further, in addition to possessing the above criteria, the invention should also not fall under Section 3 related to non-patentable subject matter and Section 4 related to atomic energy. Section 3 defines what are not inventions. This section clearly describes that if it is not an invention, then it will be a non-patentable concept and does not fulfill the patenting criteria. Therefore, a patent application may not be filed if it comes under any subsection categories in this section. There are 15 subsections starting from Section 3A to Section 3P. So the following subsections are not inventions within the meaning of this Act. Therefore, not patentable under Indian Patent Act 1970. The first subsection 3A, an invention which is frivolous or which claims anything obviously contrary to well-established natural laws. Frivolous means any invention not having any serious purpose or value or against the natural law. For example, a machine claiming for giving the output without taking any input. A machine claiming 100% efficiency. So these are frivolous inventions. They cannot be patentable under section 3A. The second subdivision 3B, an invention, the primary or intended use or commercial exploitation of which could be contrary to public order or morality, or which causes serious prejudice to human, animal, or plant life or health or to the environment. Some examples for section 3B. Inventions relates to machine used for performing theft or burglary. Bioterrorism. Inventions relates to device or machinery apparatus which assist in counterfeiting of currency notes. Inventions relates to gambling device machine apparatus. Any invention relates to cloning of humans. Inventions relates to device for housebreaking. So these are the inventions cannot be patentable under section 3B. The present slide shows section 3C, the mere discovery of a scientific principle or the formulation of an abstract theory or discovery of any living thing or non-living substances occurring in nature. First of all, we need to understand the difference between discovery and an invention. It will be helpful to understand this subsection 3C. Before we discuss the difference between discovery and invention, let's understand the meaning of discovery and invention. Discovery means the act of exploring and searching for something that already exists in nature but was never recognized or identified is called discovery. Something that has been there in nature but never came before humans and has been recognized now. Hence, it will be treated or considered as new. Invention means the creation of something unique or new, or the process of creating that never existed before by using someone's intelligence, skills, or knowledge is called an invention. The creation of something new with the help of someone's ideas or experiments comes under the meaning of an invention. Now we understood the difference between the discovery and invention part. Once again, we will see section 3C. The mere discovery of a scientific principle cannot be patentable. But the application part of scientific principle, like the product or machine or the composition matter, which is based on that scientific principle, can be patentable. Similarly, the formulation of an abstract theory cannot be patentable, but the application part of that formulation of an abstract theory can be patentable. And the discovery of any living thing or non-living substances occurring in nature cannot be patentable. Now we are going to discuss section 3D. It's a very important section. Many patent cases happened in India relates to the section. The mere discovery of a new form of a known substance which doesn't result in the enhancement of the known efficacy of that substance. Means the section states that inventions that are mere discovery of a new form of a known substance and do not result in increased efficacy of that substance are not patentable. This implied that India did not support patents for inventions which were minor modifications and prevented undue monopoly during the extended period of patent protection by the company. New form of a known substance means salt, esters, ethers, polymer, metabolites, pure form, particle size, isomers, mixtures of isomers, complexes, combinations and other derivatives of known substance. So these are the new forms of a known substance as we know. But Indian Patent Act Section 3D 1970, what it says, it has only one requirement to accept these forms as a new form. What does the requirement means? These forms should show higher therapeutic efficacy when compared to already known substance. Then only Indian Patent Act Section 3D accept these forms as a new form. Otherwise, it shall be considered to be the same substance. So any new form need to be claimed, or for any new form we are seeking a patent protection, then the new form should have higher therapeutic efficacy when compared to a known substance. The mere discovery of any new property of known substance cannot be patentable. The mere discovery of new use for a known substance cannot be patentable. Like example, paracetamol. As we know very well, paracetamol has analgesic antipyretic effect. If any company, pharmaceutical company, find anti-cancer activity of a paracetamol, then the anti-cancer activity of paracetamol cannot be patentable in India because it is already known substance. So any new use of a known substance cannot be patentable under section 3D. Mere discovery of use of a known process, machine or apparatus, unless such known process result in a new product or employs at least one new reactant, it cannot be acceptable as a patentable matter. So any known process or machine or apparatus should produce the results in a new product. Otherwise, it should use some new reactant. Then only it can be patentable. What cannot be patentable under section 3E? A substance obtained by a mere admixture, resulting only in the aggregation of the properties of the components thereof, or a process for producing such substance. To understand the section 3E, one has to clear about the term mere admixture. As per section 3E, mere admixture cannot be patentable. We need to understand what is mere admixture. A mixture would be called a mere admixture when known substances are combined and such combination merely results in an additive effect of the said substances. That is, the total effect of the composition is equivalent to the sum total of the individual components. Like example, when you add A and B substance, both are known substances, both are having individual effect. When you combine together, the resulting product, the resulting composition having that effect, that is nothing but equivalent to the sum total of the individual components A plus B means that is called a mere admixture. That mere admixture cannot be patentable under section 3E. Now we understood the term mere admixture. Mere admixture cannot be patentable under section 3E. So what type of admixture can be patentable? That is the question arising in our mind. According to the guidelines for examination of patent applications in the field of pharmaceuticals issued by the Indian Patent Office, in a composition, if the functional interaction between the features achieves a combined technical effect that is greater than the sum of the technical effects of the individual features, it indicates that such a composition is more than a mere aggregation of the features. Like example, A is the known substance, B is the known substance, each individual component A and B having some technical effects. When you add together, the resulting composition having the technical effect that is greater than the sum of the technical effects of the individual features, then it is not a mere admixture. It can be patentable under section 3E. That composition is more than a mere aggregation of the features. That's why it can be patentable. Once again, we are reading section 3E. A substance obtained by a mere admixture, resulting only in the aggregation of the properties of the components thereof, or a process for producing such substance. When you read together, it follows that in order to be patentable, a composition must exhibit non-obvious or unexpected synergism. We need to understand what is synergism. The term synergism is not defined in the Act, but in common usage, it refers to the interaction of two or more things which produce a combined effect which is greater than the sum of their separate effect. That is called synergism. Depending on the end objective, a composition having more than an additive effect or an enhancement effect or unexpected behavior, they may be regarded as exhibiting synergism under the Act. So these compositions may be patentable provided that such effect is non-obvious or unexpected. Examples of synergistic effects are improved efficacy, improved stability or shelf-life, improved dissolution profile, or reduced toxicity. So how our claim should be? To avoid attracting section 3, a claim or our new invention must show that the interaction between the components A and B involved in the invention achieves a combined effect which is different from the sum total of the effects of the individual substances. The invention should be able to show an unforeseen synergistic effect rather than a mere additive effect. What cannot be patentable under section 3F? The mere arrangement or rearrangement or duplication of known devices, each functioning independently of one another in a known way. For example, a bucket fitted with torch, an umbrella with fan, a clock and radio in a single cabinet, a floor mill provided with ceiling, a fan integrated with light, and climbing an invention for providing airflow and light. So in these examples, we can see each device functioning independently of one another in a known way. So this kind of arrangement or rearrangement or duplication of devices cannot be patentable under section 3F. Under section 3H, a method of agriculture or horticulture cannot be patentable. Example, plant manufacturing method, improved soil generation method, a method of generating mushrooms, a method of algae cultivation, weeds removal methods. So these are the methods of agriculture or horticulture cannot be patentable. Under section 3I, any process for the medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment, any kind of treatment of human beings, or any process for a similar treatment of animals to render them free of disease or to increase their economic value or that of their products cannot be patentable. Include the following under section 3I. Medicinal methods, administering medicines orally, they cannot be patentable. Surgical methods, example cataract operation. Curative methods, cleaning plaque process. Prophylactic methods, vaccination method. Diagnostic methods, X-ray blood diagnostic process. A sheep treatment method for increasing wool yield, or cosmetic surgery or methods. So these are the methods cannot be patentable under section 3I. Section 3J says plants and animals in whole or any part thereof other than microorganisms but including seeds, varieties and species and essentially biological processes for production or propagation of plants and animals cannot be patentable under section 3J. Under section 3K, a mathematical or business method or a computer program per se or algorithms cannot be patentable. Like example, a mathematical methods, business methods, computer programs, algorithms. So they cannot be patentable under section 3K. Under section 3L, a literary, dramatic, musical or artistic work or any other aesthetic creation whatsoever, including cinematographic works and television productions, they are cannot be patentable under section 3L. This type of work comes under the domain of Copyright Act 1957, hence not patentable. Literary works, computer programs, music, sound recordings, paintings, drawings, architecture, photographic work. So they can protect under the domain of Copyright Act 1957. Under section 3M, a mere scheme or rule or method of performing mental act or method of playing game cannot be patentable. For example, method of playing chess, teaching method, any method for learning, they cannot be patentable. Under section 3N, a presentation of information cannot be patentable. Presentation modes like presentation methods by using audiovisual aids are not considered to be an invention, hence not patentable. For example, railway timetables and 100 years of calendar. So it is a method of presentation of information. So those kind of presentation cannot be patentable under section 3N. Under section 3O, topography of integrated circuits cannot be patentable. Section 3P talks about traditional knowledge. It says an invention which in effect is a traditional knowledge or which is an aggregation or duplication of known properties of traditionally known component or components, they cannot be patentable under section 3p. Knowledge was with public from a long ancient historical and it passed from generation to generation. Like example, usage of turmeric or haldi as antiseptic, that is for wound healing, neem being used for pesticidal or insecticidal activities. So friends, till now we have discussed what are the inventions can be patentable in India. Particularly, Section 3 Indian Patent Act 1970, we have discussed 15 subsections in this model. I hope you understood each and every subsection. Accordingly, you can plan your patent filings for your invention. Thank you so much.